Bom dia a todos, bom dia aqui no Brasil. Para o professor Thomas já é à tarde, para a Alisson também, mas eu gostaria de dar as boas-vindas aos nossos palestrantes de hoje, agradecer muito à equipe técnica por nos possibilitar mais esta mesa, que eu acredito que vai ser uma das mais interessantes, aliás, todas são. O CODAIP cada vez enfrenta novos problemas, é algo assim impressionante como a forma como enfrenta os problemas e como dá um start para novas ideias, né? Eu sou a Ângela Kretschmann, advogada e professora na Universidade Federal do Paraná. Eu estou aqui para moderar o painel sobre o tema de a regulação da inteligência artificial e a governança nas plataformas como Wikipedia e Wikimedia. Eu vou intercalar um pouco o inglês e o português para auxiliar na compreensão de todos, pois essa mesa será conduzida nas duas línguas, mas mais em inglês por causa dos nossos palestrantes, né? Well, hi everyone, I am Angela Kretschmann, lawyer and researcher at Federal University of Curitiba, and I am here to introduce you the panel, The Regulation of Artificial Intelligence, AI, and the Governance of Platforms like Wikimedia and Wikipedia. First, I will give you some tips on how the panel works. Our presentations will be held in English, and we will open at the end for questions. Then we will dedicate the remaining time to conducting debates and answering any questions from the audience. So if you that are listening and watching, if you have questions, we ask to write it in the chat, and if possible in English, it will facilitate our debate. We will save time and misinterpretation if you do that. So, now in Portuguese, just a little more. A regulação da inteligência artificial e a governança de plataformas como a Wikipedia estão interligadas, impactando a responsabilidade civil e a democratização do conhecimento. A necessidade de diretrizes claras para a inteligência artificial, conforme discutido pelo professor Thomas, e aqui também pela doutora Alisson, é essencial para definir as responsabilidades por danos causados por decisões automatizadas. Simultaneamente, a governança de inteligência artificial na Wikipédia mostra como essas regulamentações podem afetar a produção do conhecimento, levantando questões sobre a veracidade das informações. Assim, a abordagem da regulação de inteligência artificial pode determinar se a tecnologia empodera ou perpetua desigualdades, ressaltando a importância de um diálogo inclusivo sobre a sua governança. The regulations of artificial intelligence and the governance of platforms like Wikimedia are interweaved, impacting civil liability and the democratization of knowledge. The need for clear guidelines for AI, as discussed by Professor Thomas and Dr. Ellison, is essential to defining liability for damages caused by automated decisions. Well, I want to introduce you Professor Thomas Horan. He will speak about We Shot the Sheriff, AI regulations throughout the world and their impact on traditional civil liability rules. Professor Thomas is head of the Institute of Information, Telecommunications and Media Law in Münster, lecturer of University of Vienna, former Court of Appeal of Düsseldorf and Copyright Senate. And Professor Dr. Alison Davenport, she will speak about AI for the people, how AI governance conversations impact Wikipedia. She's a California licensed attorney with experience in copyright, intermediary liability, privacy, and general internet governance. Background includes legal and political work in US and abroad. So I welcome Professor Thomas Horan that he will speak first. Hi, Professor Thomas.
Thank you, Angela. Thank you. Obrigado, Werder. Bon dia, good day. My topic is rather broad and different from Alison's topic. I will use my slides. I'm unfortunately using slides. We Shot the Sheriff is a very known song, known in the reggae world. I use that phrase, we shot the sheriff, to say that the European Union is doing the best to shoot the sheriff AI. I will explain you in a second. I will talk about civil liability for AI systems. When you want to see cases for that, perhaps everybody knows the famous example of a Uber car, an automated car who is driving. All the AI software in the car is not working very well. So the car makes an accident, and is the robot to blame for the accident? Who is responsible for the accident in an automated car? That is a famous case we use in lectures around the world. The other thing is, and there you see how important the question is. AI is used in smart metering in electricity. You see a house with occupants, with electronic equipment, all coordinated by AI. So what is happening is the AI in a house doesn't work, so that all the electronic devices produce malfunctions in providing electricity. You have a big problems because your camera in your apartment doesn't work. That was an example of Angela I just mentioned. You have problems in light, you have problems in using the computer at home. So you see a lot of accidents possible due to a lack in the software AI. We have already a traditional system of liability in civil cases. That means we have contractual liability. That's clear. That's ruled in every state differently. And we have extra contractual liability. That is most important for liability cases. And then we have a distinction between strict liability and liability based on the concept of fault, of negligence. So very dangerous for producers is, of course, strict liability, because you need to prove that it was a mistake, a negligent mistake of the producer. He is liable for every damage caused by his system if the system of strict liability applies. So I will tell you more on the new rules which the EU wants to establish for the system of civil liability caused by AI. We had in the EU, we had a lot of interesting papers on the question, how do we solve the issue of software liability in civil law? And then we had the first attempt to solve the problem by harmonizing the rules in a so-called AI liability directive. There was a proposal for a text which was published 3 years ago. That was made for improving the functioning of the internal market by introducing harmonized rules. The other aim is to promote the uptake of trustworthy AI. And the third one is to ensure that victims of harm caused by AI get reasonable protection. How is that made? This AI liability directive is still only a proposal. And they use a procedural approach. That means they harmonize the rules on the procedure to enforce liability in courts. That was done by the idea disclosure of evidence. That's an idea we have copied from the United States. Discovery. Discovery means if there is a problem in proving that AI systems have caused certain harm, you can simply say as a claimant, as a plaintiff, I want the other party to open all the files which you have internally, including emails and so on. So the claimant only has to demonstrate that he has done all reasonable efforts, then he can ask the opponent to open the files of the company. There are certain restrictions. For instance, the other party may not be forced to open its account if it has to do with confidential information, if it has to do with public security, but they, in general, they have to open all their accounts. If they don't open the accounts, there's a sanction saying, then we presume that your system has breached its relevant duty of care. So you need to prove that the harm is caused by a certain mistake in the system. That's simply presumed if the opponent, the big company producing AI, doesn't realize its disclosure obligation. So that, and the assumption then is that all things which have to do with non-high risk or risky AI systems are based on a certain non-opening of the files. So, to tell you a short story about this directive, the directive is still pending because in Brussels they have discussed for so long time the AI regulation that nobody is wanting to restart again discussions on AI liability. So they have made a long directive on AI regulation with 500 pages and 700 norms. And now they feel tired in Brussels and say, let us keep that directive in the desk. So no agreement on the final text has been made so far. That was the starting point for a second directive, which was just finished, the directive on defective products, the product liability directive. We had one product liability directive in 1995, really an old directive, and unknown for the public. In Brussels, they simply discussed a renewal, a reform of this directive, and they put everything they want to do in this new text. The Parliament has already adopted that directive, and I have to say, on the 10th of October, the Council has already agreed on the final text, so it's only to be published in the official journal and then 2 years' time waiting, and then we have a new directive in 2006. I will show you that this directive has harsh consequences even for Brazil. And therefore you need to know what is happening in that directive. What is the reason for making it? They want to adapt the regulation on product liability to the digital age and to especially AI and Internet of Things. So the question of liability for smart metering, for electronic cars, automated cars, and so on. And what they did is they integrated in the directive they solved a question in the new directive which has been discussed for 30 years. Can you say that software is a product in the sense of product liability? In the past, every researcher in Europe has written an article about the question, is software a product or only a service? I have written 4 articles about that. So it was highly discussed. Now it's standing in the final text explicitly, software is a product. So you have a full liability, and to tell you that a full strict liability for every error and mistake made in software. It does not include free open source software, but it, for instance, includes CAD, also software for architects and for building plans. So if you make a building plan using CAD, the digital tools, and you make one mistake and construct a building in the wrong way, you are fully liable under strict liability. They even extended the scope of software as a product to include AI systems and AI-enabled goods. Everything which has to do with AI belongs to the system of strict liability. So manufacturers can be held liable for damage caused by wrong software without having to prove fault. So there's as well included the definition in Article 4 that product means all movable items, even if they're integrated into or interconnected with other movable or immovable items. It does expressly include electricity, digital construction document, raw materials, and software. So a wide range of objects are now governed by the product liability system. So the scope was extended as well of the persons which are obliged to realize that system. The directive speaks of manufacturers and quasi-manufacturers. So a manufacturer of a supplier part that is integrated in or connected to the product is governed by that directive. Even if the manufacturer is based outside Europe, the importer or the authorized representative or the fulfillment service provider is mentioned as a kind of quasi-manufacturer. That means even on the third level, traders and providers of online sales platforms are mentioned as being liable under the directive. So a lot of people have now a big problem. So the object of protection is extended. The persons obliged by the directive, the scope is extended, but also the act which you have to do are extended. The manufacturer is liable for any change to the product that they have already brought to the market. In the past, we have said a manufacturer is only liable for the product in the time when the good is being sold to the market. Now you have a lifelong obligation for changes to products, for instance, in cases of software updates or machine learning. The mistake which you can make, the defect, is also extended to include cybersecurity. That means hacking. We have now a new liability for things being done by third parties, for instance, hackers or criminal employees. The Commission abolished all attempts in the past to have a minimum limitation. That means in the past, you only get money if the damage is over 500 euro. So that's not there anymore in the future. It's abolished. And you have a maximum limit of the damages which you need to pay of 85 million euro. So you see here summary, and what you find again is the rules on burden of proof, which I just explained to you. The Commission copied this old directive on liability for AI and puts the text in the product liability directive. So you have a disclosure rule of missing evidence. If the plaintiff has difficulties in proving a defect or causality between the defect and damage, the burden of proof for the plaintiff is down. That makes it quite easy to sue any manufacturer of software, including software being distributed on the net. And in addition, you have reporting obligations and remedial matters. You see why I said the EU shot the sheriffs, because now we see a really big danger that a software producer might say, I will never enter the European territory because the risk of being sued for fault negligence, for fault liability is extremely going up. At least you should take care what is happening if you are a software producer coming from Brazil. So you might say, oh, that was totally boring. What does this very strange German law professor has to say? Then I'm totally sad and depressed. But I hope you have another feeling, that is, I want to get more information. If you want to get more information, I will send you, I'm pleased to send you the slides. Send me an email, hören@uni-münster.de, address mentioned below. I will send you the slides. Perhaps you're interested to listen to that topic. If you are jogging, doing sports at the Copacabana, then we have provided podcasts. You can ask for Spotify or YouTube for videocasts where I explain more things in detail. If you want to read more and be more up to date, we have provided for 3 ebooks on this website, which I mentioned below. So one ebook on internet law, one on IT law, and a new one, brand new, on data, European data law. It's all for free, 500 pages each. So you have a lot of information, and I hope you have liked this strange topic. Thank you for listening to me. Angela, I'm finished. No, I cannot hear you. Yeah. I hope I was understandable.
I was very interested in your presentation. Thank you so much. As mentioned, my name is Allison Davenport, and I am a lead public policy analyst with the Wikimedia Foundation. The Wikimedia Foundation is the nonprofit that runs Wikipedia and several other free knowledge projects. Whereas our last presentation, I think, went for depth on a specific issue, I have been with the foundation for about 7 years, and I've seen a lot of different conversations about AI and regulation throughout those years. So I'm going to sort of try and cover the development of those conversations with a fairly broad brush, but to talk about how those governance conversations about artificial intelligence have impacted the Wikimedia projects, and how they.
Right. So, what is happening now?
Technical difficulties.
Here.
Okay, so I should just continue on?
Okay.
Okay, wonderful. I'll start then with a very brief introduction to Wikipedia and how it works for those who aren't familiar. Wikipedia is the world's largest online encyclopedia. It's available in over 300 languages, and the content is added, edited, and moderated by a large community of volunteers from across the globe. Anyone can edit Wikipedia, and the content that is on Wikipedia is licensed under a free Creative Commons license, which allows anyone to share or edit the content so long as they give proper attribution. All edits to individual pages or articles are contained in what's called an article's history, which effectively creates a transparent record of all the edits that have been made to a page so that you can go back and look and see how a page has developed. As far as the foundation goes, we strive to interfere as little as possible with the content on the projects. But we do conduct advocacy campaigns across the globe to protect our volunteers' right to free expression and assembly on our projects. With the sort of recent uptick in interest in generative AI in particular, pushing artificial intelligence conversations sort of to the front of these regulatory conversations. A lot of people are looking to the Wikimedia Foundation, the Wikimedia movement to weigh in on these conversations, because a lot of these large language models are using content from Wikipedia to source answers for people, because it is a large open source platform for factual information and topics that people care about. But the path forward to around regulating AI is not a particularly clear one, especially given the very many uses of artificial intelligence that exist. I mean, your car example is a great one. I am going to start this off by taking us back in time a little bit. So imagine it's 2017, 2018, and you're working at the Wikimedia Foundation. There's important copyright legislation being drafted in the European Union, as well as several other important territories within the world. Artificial intelligence and machine learning are very hot topics in the copyright regulatory conversation, but not in the way that you might expect nowadays, given today's climate. At that point, European regulators were very interested in preventing large-scale repeat copyright infringement to protect the interest of rights holders in the music and entertainment industries. And so they proposed several measures which would actually require the use of artificial intelligence to pre-filter content to ensure that it was not previously reported as being copyright infringing. We cared about this at the time because it would have broken the way that Wikipedia works. Users need to be able to make changes to Wikipedia that are instantaneous in order to engage with the type of collaboration that's needed to build something like an online encyclopedia, particularly one that is continually updating with the latest information from reliable sources like journalists. It also would have forced us, the Wikimedia Foundation, into a role to moderate content, which would break this very essential bargain that we have with our volunteers, that we stay out of those content moderation decisions. We were also concerned that building this type of AI filtering infrastructure, or content fingerprinting infrastructure, it was also called, might infringe upon free expression on the projects, creating infrastructure that could be used for information control later on. I think we still see trends of this with certain big swaths of content being banned. I'm thinking of a lot of the online safety regulations that have to do with children's safety that are being proposed in the UK and Australia and various other territories. And imagining how these type of regulations would have interacted with a pre-filtering system makes me very glad that we engaged the way we did back when these were being proposed, even though it was technically just a copyright issue at the time. And then the last argument may seem somewhat familiar to the discourse of today. AI simply was not good enough to do the fingerprinting that was being proposed. The systems used at the time by even some of the most sophisticated actors like YouTube, who developed their own content ID system, were riddled with false flags and would not have produced accurate results at the scale that would have been needed for compliance across the European Union. So why did I spend so long on this example from many, many years ago? I think this was one of the first times that we at the foundation really saw AI as a topic that was going to be relevant to us. And it is in a completely different context than the way we are seeing talked about today. And I think it serves as an important example of how the most pressing issues on AI today, or that regulators think are the most pressing issues on AI today, may develop with the continued use of the technology, with new norms amongst people who are implementing this in their sort of everyday use. It also shows us the sort of breadth of conversations that can be had about AI regulation. In that same copyright conversation, we were also pushing for exceptions to copyright for researchers and journalists who were engaged in text and data mining, which is another application of machine learning. Generally, the point with this example is that these issues are complex, but often the headlines and headstrong lawmakers will either miss the point of these arguments around AI or the potential issues with AI, or they are not fully informed about the technology involved. So fast forward to now, what are some of the current issues around AI that are relevant to Wikipedia and other collaborative free knowledge projects? Obviously, top of mind for many people with AI is copyright. In the United States, there have been several inquiries from federal agencies attempting to narrow down the role of copyright in both protecting works created by AI and in protecting works which are used as inputs for AI models. There is a case currently going up through our court system in which the New York Times, a national newspaper, is suing Microsoft for the use of New York Times content in OpenAI. And the result of that will eventually influence how these models are treated as a consumer of content. We have had a fairly mild approach towards copyright and AI at this point, a bit of a wait and see approach. We are strong proponents of fair use because it enables us to do some of the great things that we do with the Wikimedia projects. And so we have faith that the current interpretation of fair use within the United States, as interpreted by courts, would be sufficient to address copyright issues that would arise from at least the outputs of generative AI, and maybe more appropriate to focus on those outputs rather than the sort of methods of input. We've also worked to give our volunteers guidance on the copyrightability of the output of AIs, because that is important to us as a platform where users are uploading their own content and maybe creating that content with these large language models in some cases, which interacts with the open license that Wikipedia is under. And so we have cautioned volunteers about taking those actions without considering the copyright considerations involved. Another very important issue for us is AI as a disintermediator, as in a step between a person seeking information and getting to the Wikipedia projects. Fewer people are going straight to websites and are instead using search engines and increasingly large language models like ChatGPT to look up and consume information without ever really clicking through to the source. This has already been a problem for Wikipedia with things like the Google Knowledge Panel, with things like voice assistants, which pull content from Wikipedia without attributing it. You are most concerned here about our editor pipeline. Wikipedia relies on a lot of people wanting to share knowledge and knowing that they can do so on our projects. And if people are instead looking up information and getting that information and viewing it as very transactional and never clicking through to the Wikipedia projects, that loses us an opportunity to make an editor of a reader, which is how we sustain the high quality on the projects. Also, in a sort of very strict business sense, Wikipedia is supported by donations, and those donations come in large part from a banner campaign of ads that run on our projects asking users for donations. And so that disintermediation of people not coming directly to the Wikimedia projects may eventually impact that bottom line as well. And so we are concerned about how people are consuming information from Wikipedia and whether they are able to get back to the source of that information. One aspect that we are exploring here that a lot of open source projects are exploring is attribution, right? And what is the right way to attribute a source that goes into a large language model? Often Wikipedia is not cited at all in these as a source for these large language models when they're spitting out outputs, even if those outputs look significantly similar to the content on Wikipedia. And that not only is that contrary to our license, but it is contrary to effectively our values, which allow people to see the context for the information that they are receiving and click through to the reliable sources that back up every fact on Wikimedia. And so that is the sort of big area where we will be paying attention with these large language models is attribution. The final concern that we have is around disinformation, both being added to our projects through more effectively through the use of large language models to draft that disinformation, or in the sort of information pipeline more generally, where these large language models are feeding false facts into the pipeline that Wikipedia is using to add information to our own projects. On the flip side of that, as AI disinformation and hallucinations sort of proliferate, Wikipedia becomes even more important with its people first sort of ethos, and becomes even more important to serve as an antidote to disinformation, as a place to get context. And so we we are focusing on sort of how to fill that role. I want to talk a little bit about the principles that we use when building AI tools for our projects. We do have AI tools that our editors use on our projects. They are often used to assess the quality of articles, to identify obvious vandalism. For example, when somebody takes an article and writes something rude. They can also suggest articles that might be important to watch list for editors so that they can keep an eye on them if they're rapidly developing. Some of the principles that we use in developing these, the number one principle is human in the loop. These must be human-centric. Wikipedia is a human project. It is a culmination of a lot of human effort. And the use of tools to moderate or create content on Wikipedia are meant to assist those human editors in their jobs. Never meant to replace them, which is where we ran into issues with that EU copyright filtering plan. The AI can be really useful to human editors who have to sift through very large piles of information when they're editing Wikipedia pages, but the flaws in the machine learning technology means that that human backstop for fact checking is really, really important. We also exercise a lot of transparency when developing machine learning models. We use something called model cards, which tell you various aspects about the models that have been developed. So that includes recommended uses and non-recommended uses, ethical considerations, caveats, and recommendations, as well as information about model architecture and model weights and the data that is inputted. Another area where we're cautiously optimistic about the development of AI tools is translation. There are a lot of different languages versions of Wikipedia, and for smaller languages, there's often a lot less content and a lot less people to work on that content. And machine learning translation offers a chance for editors on smaller Wikipedias to translate content from our larger Wikipedias on sort of general interest topics to create new articles in their own language. Obviously, that comes with its own pitfalls, like potentially introducing bias from those sort of larger majority language Wikipedias. But again, this is just why human involvement is so important. And so now to finally sort of turn to the current legislation and regulatory approach to AI, we have been doing a lot of sort of piecemeal responding to requests from governments to provide our opinion on regulation around AI. Within the United States, there have been inquiries from the Copyright Office, the U.S. Agency for International Development, and the National Telecommunication and Information Administration. These types of inquiry usually fall into one of two categories. There are the copyright-related questions, which are trying to really get down to the nitty-gritty of what does copyright as written now actually say about AI technology. The others are development related, asking how to ensure AI development is balanced, it doesn't widen any existing technology gaps or inequalities. This is seen a little bit more in the international sphere. So our work internationally on AI has largely focused on the UN. We provided some input into the UN AI Advisory Board report, and we also have spent the past year advocating on various topics around the Global Digital Compact, which was just agreed upon in New York at the United Nations General Assembly, and will effectively govern the future of tech regulation. One of our sort of primary concerns that we brought up with the Global Digital Compact was that the focus on AI and development work to empower people who are creating content and making decisions that support the public interest on the internet, like those who work on Wikipedia, but that also that these are developed according to international human rights standards and through open and transparent processes. A lot of these suggestions were taken up in the final text, but generally the text is very broad on what it means by AI technologies. And I think this is a common pitfall that we see in a lot of AI regulations, which is painting these with too broad of a brush and not narrowly defining the type of artificial intelligence technology that the regulation is intending to address. I think that this will be a trend that we continue to see. I think a lot of people will use AI as a sort of catch-all term to mean both generative AI as well as the type of AI that Dr. Horn mentioned in his presentation. And I also think that another common pitfall with these regulatory approaches is focusing too much on copyright. While there are a lot of interesting and juicy questions about copyright to be addressed with AI, I think that ultimately it's a bit of a clunky tool to address the very, very broad field of changes that are brought on by this new technology. I may have left you with more questions than answers, but welcome to my world. And I want to thank you all for your time.
Thank you very much, Dr. Allison, and I apologize because I have some technical problems here. I hope you are watching me now because sometimes my video just close and I'm not doing anything. I don't know, maybe the AI doesn't like what Professor Thomas told me. I think it's a little lazy and angry with us, but anyway, we have some questions here. I don't know if we can have a small pause.
Perhaps I can ask. I thank you very much for a wonderful presentation. I've understood a totally new world of combining AI and Wikipedia. I was asking myself, what are you talking about when you talk about AI? Is it ChatGPT? And what is your relationship as Wikipedia to OpenAI?
Yes, I think generally when we talk about AI, we are talking about generative AI or large language models because that is the topic of vogue, right? And the one that is most relevant to Wikipedia because our content is sort of being hoovered up in spades by these models. In terms of the relationship between Wikimedia and OpenAI, right now there is not truly a formal relationship of any sort. They are consumers of the content that we put out. They are doing so through just simply through scraping the website, which is allowed under our license. But we definitely, while this technology is still fresh and norms are still forming, we are very interested in figuring out how to make sure that we are not sort of overtaxed by this new sort of extreme demand on our systems.
What do you think of these other models like Watson and Microsoft products and Google Bard? Do you have experiences with that as well?
Not particularly. I think the experiences are generally the similar across the board in terms of these new technologies. We haven't had a lot of time to go in depth with them. You know, we have a enterprise product that, for example, Google search pays for in order to access our API and get faster information. But they're just discussions have not really developed in that way around the use in AI as of yet, because it's just also new.
Let me ask again. When you started your lecture, I was sure you were talking about a rivalry and competition between Wikipedia and ChatGPT. But you made a very polite and sophisticated lecture on chances to cooperate and so on. So you don't feel an enemy coming up, so you feel a kind of chance.
Yes, I think, and I think if you ask different people, you might get different answers. But I think personally, I feel that part of our mission is to share knowledge as broadly as we possibly can. Yeah. And if people are seeking that knowledge through different avenues, then it is, I think, our goal to make sure that they know where that knowledge is coming from, that they can get additional context on that knowledge, and that you know, our survival is somewhat provided for in terms of connecting people to the actual projects that we do. So there is, I would say we're certainly sweating a little bit, but I don't think we view ourselves necessarily as competitors, but more so as, yeah, I think opportunity is a good word.
Okay, now Angela, it's your turn. I have more questions. I have a lot of questions to you.
Well, we can do it together, but I'm very curious also, and I want to ask it first for Professor Thomas. I'm not sure, but I think your first thesis was about software long time ago. Yeah.
Yeah.
I think so. You made a very
the old controversy on software as a product. This was the first attempt to apply the old rules on product liability to the digital world, and it didn't work at all. So and now the commissioner has said, stop it. We change the product liability directive, and we simply apply the old rules to the software world. And what I like and don't like is that they copied the American way, and there's a criticism of you in the United States, of discovery. So discovery is a nightmare for all parties. And now we have discovery in the world of the EU.
I actually wanted to, sorry, I wanted to ask a direct on that because I'm interested in this idea of copying the concept of discovery as an American lawyer. Do you think that could potentially lead to a chilling effect, not just because of liability, but because of companies wanting to hold on to their trade secrets?
Yes, of course. I've been involved in many discovery procedures in Seattle against Microsoft, against Amazon. That was a nightmare of thousands of emails, and we had 3 months of preparation for a discovery procedure. So and the commission even made the mistake. They had in the first draft of the AI liability directive, they have mentioned trade secrets are out of the scope of discovery. That rule is not being found in the final text of the product liability directive. So for the company, no chance to say trade secret, sorry for saying no. So it will be a long and hard time, and I think we really shot the shelves.
Yeah, but I was wondering in the beginning of your speech, Professor Thomas, maybe the shot don't kill, just give a scratch, but
a very hard crash, very dangerous, very painful. So I wonder what will happen, and let me use my chance to use every minute to ask Alison again,
okay.
Because I want to know, how do you feel about the EU and about the EU regulating AI? Do you like? Do you know? First question: do you know the EU AI regulation of Europe? Have you seen the text? Not read the text because it's impossible. And do you like it? And second question, that is a very American question. You had a plan in California to make a similar draft in your parliament in California. What happened with that draft?
I'm afraid I'm going to disappoint you because I am not super well versed on either of these. Yes, we gave a little bit of input into the EU Act. I think that tends to fall into my feelings about things being painted with a bit too broad of a brush, right? The regulation is trying to cover a lot of different applications of this technology, and I think doesn't quite narrow in when it needs to. As for the California law, yeah, I am not as well versed with it. We tend to take a little bit of a wait and see approach to regulations in the states, and so that's what we did with that one.
And again, using the chance to ask any question. What do you like more? The sandbox experiment, for instance, in Russia, they have a clear sandbox model. Even in China, we find sandbox. The EU has decided to make a huge codification. What is your approach? Remain silent, let the people work, or have a huge regulation?
I think I would prefer a third option, which there are a number of smaller regulations that are much more industry focused. But if given the sort of two choices, I do think that leaning towards regulation, I appreciate. I think one thing we saw in copyright law with the EU was that the EU filled a sort of vacuum that was needed for this very big comprehensive copyright regulation. And as you mentioned, the countries sort of taking the sandbox approach, I think are politically incentivized to take that sandbox approach because of some of the disinformation and other risks of sort of unregulated AI. So while I do think that sometimes the regulation can be heavy-handed, I think I appreciate that the EU is stepping into that role so that the sort of general norm does not become that sandbox being led by, for example, Russia and China.
Okay, thank you. Angela, your turn.
I'm sorry. I'm sorry. So I was listening, Alison, and I think Wikimedia become more influent with AI. I think I'm not wrong. But what is more troubling, the AI producing works that are subject of copyright, or the AI use of Wikipedia data for you?
Now I'm the one who's unmuted. I do think it's the use of Wikipedia's data. I think that it will be challenging to deal with the scale at which people can create new information and new resources online, particularly inaccurate ones, which will definitely impact Wikipedia's pipeline, because everything on Wikipedia needs to be cited to a reliable source, and if things that look like reliable sources keep popping up, there's a lot of education that needs to be done about that. At the same time, because of that disintermediation risk, I think the use of our content is our sort of number one most existential issue, because it touches both upon the actual way that people interact with our content, whether that content is portrayed accurately, or if AI hallucinates some of what we said, and also how people gain access to that content and gain access to becoming a Wikipedia editor.
Okay, so we are now a little, we need to rush a little, so I don't know if Professor Thomas has more questions.
A lot of them, but no, I don't want to disturb your time schedule.
Okay, so I just give a final minute for each of you to say goodbye for us, and then we will close this window.
Perfect. Thank you very much, Angela. Angela, you are so wonderful presenting us. I wish to thank you a lot. And I have found a new colleague in order to discuss with her all the topics I want to know. So we stay in contact and have a follow-up of questions and answers. Thank you very much.
Thank you. Alison?
Yes, thank you again so much for having us. Professor, I've written down your email address, so we will absolutely stay in contact. And yeah, thank you for giving me the opportunity to speak about what's a somewhat complex topic for us still and evolving.
Thank you very much. I thank you, Professor Thomas Horen, and thank you, Dr. Alison Davenport. And I thank the public also, and Professor Marcus and Kodaip and all technical equip that we have here. Thank you very much. I hope to see you soon again. Bye-bye.
Bye-bye.